Welcome back to Talk Testimonies. We're ready to dive deep into another Supreme Court case today. This time, it's Thacker v. Tennessee Valley Authority. Kind of a mouthful, but it boils down to a really interesting question about, when the government can be sued.
Right, because on the surface, it seems pretty straightforward. I mean, the TVA, the Tennessee Valley Authority, it's this government-created corporation, right?
Yeah.
And they have this clause in their charter that says they can sue and be sued. Pretty clear, you'd think.
Exactly, you can sue them.
But the catch is they're not covered by the usual set of rules for suing the federal government, the Federal Tort Claims Act, the FTCA. So the question the Supreme Court had to grapple with was, does this sue and be sued power mean they can be sued for anything and everything, or are there hidden exceptions?
Interesting. So that's the core legal issue at play here.
Exactly.
So spoiler alert for our listeners, what did the court ultimately decide?
The Supreme Court actually came down pretty definitively on the side of, no, there isn't some secret implied exception for the TVA. In a unanimous decision, they basically said that just because the TVA can sue and be sued doesn't mean they get to slip out of liability for everything based on something like a discretionary function exception, which is what they were trying to argue.
Okay, I think we need to back up a bit and give everyone the context here. This case stems from a real-life tragedy. Can you set the scene for us? What actually happened to bring this case before the court?
Okay, so picture this. You're out on the Tennessee River, beautiful day, enjoying the water. Tragically, Gary Thacker, who was piloting a boat, ended up colliding with a downed power line that was owned and operated by the TVA.
Oh, no.
Serious injuries, a fatality. It's awful. And naturally, Mr. Thacker filed a lawsuit against the TVA alleging negligence. I mean, his argument was essentially that the TVA hadn't properly installed or maintained those power lines, and they didn't do enough to warn boaters about the potential danger.
Yeah, that makes sense. You'd think they'd have a responsibility there to, ensure safety.
Absolutely. Now, the TVA, being, a government entity, they countered with this age-old legal defense, sovereign immunity. Basically, they said, you can't sue us unless we say you can. And get this, both the District Court and the 11th Circuit Court of Appeals initially sided with the TVA.
Really?
Yeah. They applied a test that's similar to what's used under the FTCA, the Federal Tort Claims Act that we mentioned earlier. It boils down to looking at whether the action involved judgment and choice, discretion. And their reasoning was because the TVA had to make certain choices about how they were going to install and maintain those power lines, those were discretionary decisions, and therefore they were immune from this lawsuit.
So that's where the Supreme Court steps in, right?
Exactly.
What was it about this specific case that made them decide, nope, not buying it?
Well, a couple of really important things. First, the Supreme Court, they looked very closely at the actual language of the TVA Act, the law that created the Tennessee Valley Authority. And that act has this really broad sue and be sued clause. It doesn't say you can sue the TVA except when, or you can sue them for these things but not these other things. It's very open-ended.
I see. So from the Supreme Court's perspective, the TVA Act didn't provide this discretionary function exception that the lower courts had relied on.
Exactly. And the second key point the court focused on was this. Congress, when they created the TVA, specifically chose to exclude the TVA from the Federal Tort Claims Act. And, like we mentioned, the FTCA, it's the law that broadly lets people sue the government, but it does have that carve out for discretionary functions.
So the Supreme Court's thinking is, if Congress had wanted the TVA to have that same protection for discretionary actions, they would just left them under the umbrella of the FTCA.
Right. Or they could have written that exception directly into the TVA Act, but they did neither of those things. And that, to the Supreme Court, signaled that Congress intended for the TVA to be more accountable to lawsuits, even for decisions involving discretion.
Now, I remember reading about this case. The court brought up another case, Federal Housing Administration v. Burr.
Oh, yeah, Burr. That one's important because it sort of sets the stage for how we think about these sue and be sued clauses. Basically, Burr acknowledged that even when you have this sweeping language, there might be some extremely limited, implied restrictions.
Implied, meaning not directly stated in the law, but sort of read between the lines.
Yeah, and only in really specific situations. The Burr case kind of gave us this framework for when that might happen.
Like what?
So imagine if allowing a certain type of lawsuit would basically make it impossible for the government to function effectively, completely hamstring their ability to carry out essential duties. Or if it fundamentally clashed with how our legal system is supposed to work, our constitutional principles. In those incredibly narrow instances, Burr suggests there might be an implied restriction on suing, even with a sue and be sued clause.
So I'm guessing that's the argument the government tried to make in the Thacker case.
Oh, absolutely. They were basically saying, look, if we allow the TVA to be sued every time someone second guesses a decision about where to put a power line or how to maintain it, it'll completely tie their hands. They won't be able to do their job effectively. Plus, they argued, it violates the separation of powers, having courts meddling in these kinds of executive branch decisions.
Seems like a strong argument. Did the Supreme Court buy it?
Not really. You see, they kind of flipped the script on the government. They emphasize that ultimately it's up to Congress to decide when the government can be sued. If Congress says an agency can be sued, even for discretionary stuff, that's their call, and doing so doesn't automatically mean the Constitution's being violated.
Congress makes the rules.
Right.
Got it.
Right.
Okay, so we've talked about the sue and be sued clause and Congress's intentions and all that, but the court also focused on the unique nature of the TVA itself, right?
Yeah. The TVA is an interesting creature. It's not your typical government agency. They pointed out that it's kind of this hybrid entity. It does do things that are very traditionally governmental, like they can use eminent domain to acquire property. They have their own law enforcement, things like that.
Yeah, powerful stuff.
For sure. But at the same time, a huge part of what the TVA does is very commercial. They produce and sell electricity, which is, something private companies do all the time.
That's an interesting point. And how did this whole governmental versus commercial distinction play into the court's thinking about whether there should be an implied immunity in this case, building on that Burr case we discussed earlier?
Well, the court basically said that when a government entity is acting in a commercial capacity, they should generally be just as liable to lawsuits as any private company doing the same thing.
Makes sense. Level playing field.
Exactly. And they pointed to Burr and other cases involving entities like the FDIC and the Postal Service. These entities also have these sue and be sued clauses, and they all do things that are kind of commercial in nature. So the court essentially said, look, the possibility of this implied immunity from Burr, that really only kicks in when you're talking about lawsuits that target core governmental functions, not when you're acting like a business.
Okay, I think I'm starting to see how this all fits together. So after the Supreme Court made this decision, what happened next? Did they just say, okay, TVA, you lose, you're automatically liable now?
Not quite. They sent the case back down to the lower court with some pretty specific instructions. The court basically said, all right, lower court, you need to figure out first whether the actions that Mr. Thacker alleged were negligent, about the downed power line, and whether there were adequate warnings, whether those were governmental or commercial in nature.
Okay, so a two-part test. First, figure out governmental versus commercial. What was the second part?
Well, they said that if the lower court decides those actions are commercial, then game over. The TVA can't claim immunity. They'd be subject to the same legal standards as, say, a private power company in a similar situation.
But what if the lower court says, nope, those were governmental actions? Does that automatically mean the TVA is off the hook?
Not so fast. If it's governmental, then the lower court has to move to the second step of the Burr analysis, remember? They need to determine if allowing this specific type of lawsuit alleging negligence in this particular way would seriously disrupt that governmental function. Would it cause what Burr calls grave interference?
So it's not just a blanket immunity for any governmental action. It's really context specific.
Very much so. And the Supreme Court was pretty clear that this is a high bar to clear. The TVA would really need to show that being subject to this kind of lawsuit would fundamentally impede their ability to carry out that particular governmental function.
It sounds like this decision from the Supreme Court really clarifies things, especially for these government-owned corporations like the TVA that aren't covered by the usual rules under the FTCA.
Definitely. It reinforces this principle that when Congress says you can sue this entity, they really mean it. Those waivers of sovereign immunity are supposed to be interpreted broadly, not narrowly. It's not just about protecting the government from lawsuits willy-nilly.
And I guess the other big takeaway here is that the court is hesitant to just make up new exceptions to being sued, especially when Congress has already made very specific decisions about how a particular agency should be treated legally.
Exactly. They're basically saying, Congress did their job, we're not going to second guess them and create loopholes that they didn't intend to create.
All right, now it's time to put on our imaginary robes and step into the 10th chair here at Talk Testimonies. If we were on the Supreme Court, How would we have ruled in this case?
Okay, so channeling our inner Supreme Court justice here, Talk Testimonies, sitting as the 10th chair, we would have sided with the majority. We'd be joining that unanimous decision to reverse what the 11th Circuit did and send the case back down for further review.
Why is that? What's the reasoning behind that decision from the 10th chair?
Our reasoning lines up pretty squarely with what the majority said. It boils down to looking at the language of the TVA Act, that sue and be sued clause, and the fact that Congress specifically excluded the TVA from the FTCA.
Right, we talked about that.
To us, those things together pretty strongly suggest what Congress wanted. And at the end of the day, it's Congress's job, not the courts, to decide how these waivers of sovereign immunity work. If we started making up broad exceptions for discretionary functions, especially for something like the TVA, which does a lot of commercial stuff, we think that would be overstepping our role.
Overstepping and potentially undermining what Congress put in place.
Exactly. Now, the government made some arguments based on the Burr case, about how lawsuits would interfere with the TVA's work, but we just didn't find those arguments convincing enough. They didn't meet that really high standard that Burr sets for implying these kinds of limitations.
So what kind of impact might this ruling from the 10th chair have on future cases?
Well, our concurrence would definitely reinforce this idea that courts really need to look closely at the specific laws that Congress has passed when dealing with these sue and be sued situations. It's not a one-size-fits-all approach. And being excluded from the FTCA, that's a big deal, something courts should really take into account.
And this whole distinction between governmental and commercial activities, that seems like a pretty key takeaway as well.
Absolutely. Our ruling would further emphasize that courts need to be making that distinction and not just assuming that any action taken by a government entity is automatically shielded from lawsuits.
Makes sense. Well, folks, that's our deep dive into Thacker v. Tennessee Valley Authority, a case about accountability, about the limits of government immunity, and about the importance of reading the fine print when it comes to what Congress actually intended.
Really fascinating stuff. At the end of the day, this case highlights that even when you're dealing with a government entity like the TVA, it doesn't mean they get a free pass from being held responsible for their actions, especially when they're operating in a way that's similar to a private company.
And remember, everyone, our analysis today, including our hypothetical ruling in the 10th chair, is just for informational purposes. It's not legal advice. This is a complex area of law. And if you have specific questions, you should definitely consult with a legal professional. Always good advice. Thank you so much for joining us for this deep dive into Thacker v. Tennessee Valley Authority. It's been a pleasure exploring this case with you. We'll catch you next time on Talk Testimonies.